Welcome again to Basic Criminal Justice System Overview, sponsored by the ABA Commission on Domestic and Sexual Violence. Today's webinar will be facilitated by Vivian Huelgo from the American Bar Association Commission on Domestic and Sexual Violence, and Jane Anderson from Equitas, the Prosecutor's Resource on Violence Against Women. Jane and Vivian, I'll turn it over to you.
Thank you. Welcome, everyone. Thank you for spending your time with us this afternoon as we go through what will hopefully be a really nice introduction for those of you that might be doing this work about the criminal justice system and how this is going to affect the vacatur or expungement motions you may want to file on behalf of your clients. So I'm Jane Anderson. I'm an attorney advisor with Equitas, the Prosecutor's Resource on Violence Against Women. We're funded through various sources, but primarily through grants from the Department of Justice's Violence Against Women office, and we provide training, technical assistance, and case consultations to prosecutors as well as any allied professional that's really doing this work that intersects violence against women, domestic violence, sexual violence, human trafficking, stalking, witness intimidation, that intersection between the crimes and the criminal justice system. So we are funded to support detectives, victims' rights attorneys, victim advocates, service providers, medical professionals. I am a former prosecutor myself. I practiced in Miami-Dade County for about 8.5 years, the last 4 of which I spent working on human trafficking cases. I co-founded the unit there in 2010 and really sort of worked my way through a lot of those very beginning challenges, tried a lot of human trafficking cases, and in fact filed on behalf of victims motions to expunge once we got that on the books in Florida, and even I think before we had official human trafficking expungement statute, and led to some confusion in the clerk's office. The prosecutor's office was actually filing some of these motions, but I was lucky enough to come from an office that really supported the work. So I'm happy to be here today, and like they said, ask questions as we go along. We're going to try to leave some room at the end, but Equitas and me personally, I'm always here as a support or resource for any of you on the call. Vivian?
Thanks so much, Jane. I'm Vivian Huelgo, Chief Counsel for the American Bar Association Commission on Domestic and Sexual Violence. And similar to Equitas, we provide, we're funded primarily through the Department of Justice Office on Violence Against Women to provide technical assistance and training to LAV, or Legal Assistance to Victims Grantees, under the Violence Against Women Act, or VAWA, mainly on civil issues. And so where prosecutorial or criminal justice issues come up, we tend to refer to our friends at Equitas. But we can answer individual questions. Sometimes it's case referrals. Sometimes it's strategic questions on how to develop a pro bono program or how to wrestle with some challenging judges in a particular jurisdiction, how to find experts. There are just a range of questions that involve technical assistance that civil attorneys, but also other allied or legal professionals have, and they contact us through our website, and you'll see that website address at the end of the presentation. I want to thank Equitas and Jane Anderson for joining us in this first kind of kickoff session for the webinar series, and say that I too started out as a prosecutor in the Manhattan DA's office quite some time ago, but have spent most of my career as a liaison to the criminal justice system and working from a civil perspective at several nonprofits and gender-based violence organizations in New York City. Thanks, Jane. We can move forward.
Okay, thanks, Vivian. So hopefully this afternoon you're going to be able to take this information and use it to review any criminal histories that you're looking at on behalf of your client, and sort of note maybe the differences between an arrest and a citation and how that could possibly affect the work that you're doing. And then from that, it'll give you some guidance as to what kind of police reports you may want to gather, how you can analyze some court dockets and case files so that you are ensuring you're filing the right motions and you're covering everything you want to cover to get your client's criminal history vacated or expunged. And then, just having this information to better advise your client about what to expect, what may be going on still presently in any criminal matter, and just sort of some of those intricacies of language and nuances of criminal law.
Thanks, Jane. You know, the thinking behind this particular session was that we know that a lot of the folks who are working with survivors of human trafficking doing vacatur and expungement work are not necessarily deeply versed and experts in their criminal justice systems. They might be working as advocates or clinicians or civil attorneys or legal services on the civil side. And so we wanted to be sure that they have an opportunity to get a kind of a foundation in understanding the criminal justice system as they engage in that work. So to that end, we'd love to know who you are with us today. Are you in fact a public defender doing other criminal defense work? Are you, as we mentioned, a civil legal services attorney? Are you an attorney who's at a firm or a solo practitioner but who's doing pro bono work on behalf of survivors of human trafficking? Are you an advocate or a social worker? Are you in fact a prosecutor, a judge, or some other kind of law enforcement? So if you would just use the poll and click away and let us know who you are. We're going to hold the poll open a little bit longer so that everyone has an opportunity to click and let us know who the majority of folks on the call are. I can see that you've checked in from a number of different organizations, and so we're eager to see that most of you, we're happy to see that most of you, let's see, it looks like 44% are civil legal services attorneys, so civil lawyers, and then a lot of social workers, advocates. And I hope that I'm reading that right. And then we have a little over 10% of what we call other law enforcement. So those could be police, sheriffs, or in fact advocates who are working out of law enforcement. That might be the case. And again, just a reminder that we're going to be taking questions throughout. And so if you want to post questions, use the question box.
Okay, great. So let's move on from there and look at criminal law and records databases. And it looks like this slide isn't showing up right. But what we wanted to say is, like, there are several different places where you can look, whether it be local or statewide or federal. The unique thing is that criminal law is state law. So there is no universal language that's used as we cross from state to state. And of course, when we look at human trafficking and the victims, we should almost be expecting that we're going to have to come up with and deal with various state laws as we do this work. And then not only that, but there are going to be some county and city codes that could be implicated. There's going to be multiple police and sheriff's departments within any jurisdiction. So I practiced in Miami-Dade County, a very large county, and we had 67 different law enforcement agencies within our county that we were regularly working with. And so their forms maybe look different. The way they enter things into systems may look different. So it really is something that could cause some difficulties as we go there. Not only that, but there's just different courtroom practices and jargon that you're going to hear. In fact, working in Miami, I was once specially assigned a case in Broward. That's the county north of Miami. It's about a 20-minute drive. And I had to go to one of their courtrooms, and it was like I had walked into an alternative universe. I had become so comfortable with my everyday courtroom sort of nuances, and it was incredibly foreign. So I can imagine you guys that aren't, maybe spending most of your time in a criminal courtroom, this can be fairly confusing. So hopefully that's what this webinar will help us kind of tease out. So here's some of the places we want to look. Number one is the NCIC, and then state databases, police records, court dockets, and court files. And I'll go through sort of one by one what all of these are. So NCIC is the National Crime Information Center. That's our national database. When we watch TV shows and movies, that's how everyone's sort of getting all this instantaneous information about offenders. It does not work that way in real life. It's a voluntary system, as many of you may be hearing about when it comes to firearm prohibitions. Some states don't enter information at all. Some states enter in limited information, and every state enters information based on, sort of human entering, so that it can often not be consistent nor accurate or up to date. But in its best form, it does show arrests, dispositions of cases. I found that the one that was probably the least accurate in the work that I was doing. It also shows missing persons, and sometimes stolen property can be listed in there as well. State databases are going to be developed by the state and for the state. A lot of times they mirror what the NCIC looks like. So again, using my personal experience, there is an FCIC. So NCIC was the national database and FCIC was the Florida database, and I think many states have something developed like that. And again, you're going to have the same issues with consistency between local and county information, because of the fact that it does rely on the individuals to input and update the information.
And Jane, I just want to echo what you said earlier, and just because it applies here, all criminal law is so local. I would find that sometimes I would check the New York State system where I was practicing to get information on records. I would find some information, but then when I actually called the DA's office or the police department that was just in the next county over, I would find that that information was not 100% accurate, again, because people are inputting it themselves. Sometimes there are delays and backlogs in inputting that information. And so you might have to do some follow-up calling to verify and confirm the information that you're talking about.
I would say you always would have to kind of confirm. Thanks for bringing that up, Vivian, because, and in particular importance to the work that you're doing, one of the things that I always felt is that it might have been entered at the time of arrest, but nobody really was following up with dispositions. And so figuring out what happened to a case was really very unreliable to look towards these databases. So that follow-up phone call and really getting something more clear. But these databases give you an idea of, like, where should you be looking? Who should you be calling for that follow-up information?
Right.
Thanks. So the police reports, that's kind of getting back to that nitty-gritty. And getting copies of these. And of course the police reports, and especially, in cases that might be, we're assuming a lot of this is going to be based on a misdemeanor arrest for prostitution. These are not going to be very involved reports for the most part, but they will give you the facts alleged, the witnesses, if any, what charges were arrested by the police officer, what charges they arrested the person on, and what officers were involved. And all of that can be helpful as you're doing, putting together some sort of motion. But it's never going to tell you sort of what happened after the arrest. And of course, there will be a wide range of detail and accuracy dependent on the officer, whether that be in the form of just, somebody submits a one-sentence report, or somebody follows up with additional reports. So it's going to be really very varied. And in fact, I would have cases where if some major operation was being conducted by a jurisdiction, they would have pre-typed the arrest form. So it had pre-typed information, and then the officers would just fill in names and particular language. And so that when we got the police reports, they were halfway just typed, that you could tell they were done in advance, and then somebody had filled in, somebody's name and the exact words that were used in the solicitation, but everything else was pre-printed. So obviously that's not fair.
And Jane, that might be for something that is like a big, massive, maybe sting, or for like these kinds of cases, maybe taking down a brothel of some kind where they know they're going in at a certain date or time, and so they can pre-print that information. I don't want to get into what the cross-examination of that might be, but right, I mean, like that's not, someone's walking down the street like a patrol officer and comes across something and it's one person that's being arrested. That's much more likely to be, just like they kind of quickly fill something out.
Yes. So then court records, these can be done both by manual searching, and more you're going to find online databases that you can look through. And there'll be a difference, though, between what you can get via public records and then what you can get if you're an attorney. And so that might be an online portal that allows you to sort of give them credentials and get that additional accessibility online, or it may be a situation where you have to go down to the courthouse and show your credentials and get the information that otherwise wouldn't be available to the general public. These court records will show you what happened, and they're, what is running this whole system, but there are an incredible number of abbreviations, acronyms, and very specific terms that will be included in court records, and you'll almost need like a translator to sort of wade your way through what these may mean. And then the case files would be something that would be kept by a prosecutor's office, and they would include the court reports, they would include the prosecutor's notation of court proceedings, but they will also have work product within them. So if you are filing, a motion, or if you're filing to get copies of these as public records, you may not be getting the entire prosecutor's file because some of the information may be redacted due to work product. But I kind of have a sense, and Vivian, let me know what your thoughts are. I think generally prosecutors' offices and those that I work with have very sort of open file systems or sunshine laws where you're going to get almost everything if you're able to file those motions or requests for public records of prosecutor files. So that's a great way to get, I think, a pretty complete look at a case. And and the great advantage is the prosecutor is going to use that file to, look at your motion and evaluate your motion, right, and respond to your motion. So you can get sort of the same facts that any prosecutor is most likely dependent on as well. So how does a criminal case begin? Now we're going to be working with sort of a flow chart. I don't want you to get scared when you originally see this because we're going to break it down in more digestible pieces. But this is sort of an original sort of look at how a case goes through our criminal justice system. And you can see at the top it either begins with an arrest or a citation. And let's break that down a little bit.
And all of these different steps are not always clear to the folks, to your clients, right, to the survivors that you're working with in terms of how they are moving through the flow chart. And we also just, note, again, a lot of criminal law is local, but for the most part, in some way, shape, or form, criminal law follows generally this process and this flow chart.
The constant caveat, right?
Yes.
Everything's going to look a little bit different. Okay, now let's see. Mine is.
And now physical arrest, Jane, right, is going to look like what we see on TV. That isn't always the case about a lot of the things that we're talking about, right, in the movies and online order. But physical arrest meaning handcuffs in the back of a patrol car, mugshot fingerprints, that does physically look like what folks are familiar with.
Absolutely. So that physical arrest is going to mean it's sort of going down to the idea of custody, right? But they may also have this arrest that turns into a promise to appear. And so that's going to look more like somebody got a ticket. And so if you ask the question of a client that says, were you arrested, they very well may answer no, even though the systems, the police records are all going to kind of look like an arrest. And it makes a lot of sense that if I didn't get handcuffed in the back of a car, then I'm not processing it as an arrest.
And so it should not seem, I think, if you find records that document an arrest, when you've asked that question and the client says no, that should not be an inconsistency that feels like a lie or an inaccurate statement to you. We just want to share this with all of you so that you're aware of the fact that as you're moving through this process, it may not feel like an arrest, and so you're generally answering that no, I wasn't arrested. I basically got a ticket. I got a piece of paper.
And I can't tell if you guys are having any problems with my slides going forward, but hopefully not, and it's only showing up on my computer. I've got an example that's currently on my screen that shows an arrest affidavit from Miami-Dade County. Thank you. And, this is probably what you're very familiar with. They're called different things. Just as an example, for jargon-wise, we would call this an A form. Why would we call that when on the top of it, it clearly says complaint arrest affidavit? That's just one of those things. But that's going to be pretty familiar looking to those. However, at the bottom of that form is where there's this additional checkbox that says, I understand that should I willfully fail to appear before the court as required by this notice, I may be held in contempt of court or a warrant shall be issued. That is what we would call a promise to appear. So there is this arrest affidavit provided, but there is no physical arrest. And instead, at the time of the non-physical arrest, they're provided this documentation, a carbon copy of this documentation, and they're provided notice to appear. Now, do they understand that at the time? I think that's a good argument for those who are representing a victim that failed to appear. This is not, I think, incredibly clear, but that's kind of the thing you might want to be looking for as you do a records check. Now, in converse to that, you may be working within a jurisdiction, especially I would say in like where we're looking at county and city codes, where someone may receive a citation. In particular, I saw this a lot where someone was getting cited, not for maybe solicitation of prostitution, but for loitering for the purpose of prostitution. And so, the sort of nuances of code violations. And in that case, these really do look like a speeding ticket. They're from a book that your patrol officer keeps in his pocket, and it's written up real quick, and it's sort of handed out like that. So here's an example. I've kind of split it into two, but as you can see, it's really just, I've never had a speeding ticket, but I could imagine it might look like that.
And I just want to say that, again, for folks who are going through this process, it does all go by in a blur. And so, again, understand that you're trying to get information possibly during an interview with a client, and you're not getting the details that you're looking for. The records can help fill in some of that information because it does all go by quickly. It can feel like a lot of paperwork. It can feel like people are saying a lot of jargon really quickly, everyone from law enforcement to clerks to even a judge, at some point. And so just understand that part of the process of working with your clients is to talk to them about this process that they have experienced, but also understand that you might need to fill in some information based on this information that we're sharing with you.
And so I think we kind of went through what that physical arrest looks like, but one of the things that, in addition to that physical arrest and what that means, is that not only are they probably going to be able to relate to you that they were arrested a little bit easier, but once that booking process occurs and fingerprints are taken, those fingerprints go into a computer system, and that person is linked to other cases. So how this comes up is that if someone was arrested in a particular county and they had prior arrests, once they get arrested this instant time, fingerprints go in, and then it's all linked up in the system, and if somebody is to print that person's criminal history, it now shows all of those linked cases by fingerprint. So I've got somebody's criminal history. As a prosecutor, I get that at the time of, a bond hearing. I'm given, the initial arrest report, and I'm given their criminal history instantaneously. That happens. And so I can say, oh, these are their prior contacts with the system, and they're all linked. And so if you're doing a criminal history and you're trying to figure out, okay, what are all my cases that are out there that the victim was involved with, the problem is that if the victim was either cited or provided with a promise to appear, some alternative to physical arrest where they are not booked and not fingerprinted, that case may not be linked in the system. And so if you just do a criminal history and you just get those cases where they were physically booked, you're potentially missing out on other criminal cases that are out there that were initiated through something other than a physical arrest. So sometimes you have to dig a little bit deeper. So once either a citation or arrest has occurred, within 24 hours, someone is eligible for a bail hearing. They have a right to a bail hearing. So after the arrest, if they're in custody, they have this bail hearing, sometimes called a bond hearing. It happens within 24 hours. That's a time when the case just at first flush is provided to a judge who determines, okay, there was probable cause, and here is a bond or some sort of bail condition. Some people are released on their own recognizance. They don't have to pay anything. Sometimes they're released after posting a bond. Sometimes they're released pending some other sort of release conditions that might include, house arrest with an ankle monitor or something like that. So there's going to be all sorts of varieties. There is a situation where someone is in custody, but they're allowed to bond out prior to that hearing, so they never go to that hearing. So there are circumstances where somebody's been physically arrested and they've never physically appeared at a bond hearing. And again, any time when something doesn't fit this sort of standard linear process of a case, you're ripe to have a situation where a victim is not understanding exactly what happened. So if someone was bonded out immediately, their trafficker may come down and pay the $500 standard bond, they never saw a judge. Well, that's not going to look like they were in custody. They may not even have notice of what happens next, and they think, oh, well, it just went away. I paid a fine. That could definitely be translated to that kind of thing.
And Jane, before we go to the next slide, I just want to say again, we have the chat box open for questions. And yes, this recording and slides will be posted on our website. We'll show the website at the end of the session. Jane? Perfect.
So now next step, right, if somebody's been arrested, but how does that actually get charged? And again, something that not everybody, a layperson, doesn't necessarily understand, that there's that charge at the time of arrest, and then there's the charge that a prosecutor may bring. So the arrest decision versus the charging decision. So at the time of arrest, the police are making that determination based on a very low bar, this low bar of probable cause. That's all they need to articulate at the time of arrest. That's all that the judge is analyzing at that bond hearing. However, there's usually this sort of lapse of time between that arrest and then when a prosecutor's office makes an additional determination of filing, charges. So, and not in every case is this done in the same sort of time frame. But in general, the prosecutor is tasked with reviewing the evidence and speaking to witnesses and then making that decision of whether to file charges via an information or an indictment. We're thinking mostly about cases that are going to come to us where the victim of trafficking has been arrested for misdemeanor level crimes. However, there are, lots of cases where one of these trafficking victims may have a criminal history that includes felony type crimes. So as you can see the seriousness of the case, the more in-depth this charging decision process is going to be, right? If all that it is a patrol officer who made an arrest on the street, this is going to be a pretty quick review process, not that in-depth, probably just filing charges via information. However, if it's a case where the victim has been arrested for trafficking or for maybe an aggravated assault on a buyer, you're going to have a much more in-depth process where witnesses will be brought into the prosecutor's office and where there may be a grand jury that returns an indictment. But that's all the same process, just in a sort of simpler or more complex form of the charging decision process. So misdemeanor charges are usually prosecuted by information. In some jurisdictions, they can just be prosecuted off of that arrest affidavit or complaint. And in a rare well, I don't know, not so rare. I'm hearing about it more and more. In some jurisdictions, they actually just have the police officer come in and sort of prosecute the case based on their own police report. So
which is almost akin to what happens in speeding cases, right? Like in speeding ticket cases. But also, I mean, just to take a step back, Jane, like, and when we're talking about misdemeanor versus felony charges, I mean, to really bring it down to very simple terms, and again, criminal law is local, but these are lower level kinds of cases. So loitering and prostitution would be considered misdemeanor or lower level kinds of cases. When crimes or alleged crimes involve weapons and that kind of thing, those are much more likely to be higher level kinds of cases and to be what are considered felony crimes. If you had mentioned trafficking, that would be considered, I think in most jurisdictions, a felony level, more serious kind of case. There are some lower level kinds of physical assaults that could come under that come under misdemeanors. And so again, it varies. There's no way to know unless you check, right, if we're talking about a misdemeanor or a felony. But definitely where you're talking about police officers moving forward, these are going to be more simpler, lower level kinds of cases.
Yes, and thank you for always bringing it back, because even though I'm like sitting here trying to simplify things, I'm probably still using jargon. And the question came in about whether victims themselves or prior defendants would have access to their own records, and that depends on jurisdictions, but usually they may be given a copy of any police report at the time of their arrest, so they may still have those copies that they were provided at the time. But if they want to go back and get copies, typically they have to go through the same process of, filing a request and potentially even paying money for copies being made.
And if it's an open case, meaning they're going to trial, they're headed to trial, then at some point there's discovery of some kind, which we'll talk about a little bit later. But there is a process for getting that information.
Yes. So the charging decision happens in the time between that bond hearing that was done almost immediately and the arraignment. In my experience, it's usually about a 21-day window, but can be more or less. Usually it would err towards the less side. Charges can be brought via an information, which is essentially just a piece of paper that the prosecutor files and signs off using their barcode and their sworn status as a prosecutor. An indictment is what is given after a grand jury is impaneled, and there may also be a probable cause hearing that is done between the judge in front of a judge. So all those things kind of can play into that charging decision. But once the charging decision has been made, an indictment has filed, that's when you're going to then have an arraignment. This is typically the next time someone would appear in court. And typically, if you've been arrested, you are required to appear at your arraignment. That would be the time that you were given notice for when you were released on bond, or the time you were given notice for if you were provided a notice to appear. So this is often a time where the defendant is required to come to court, and if there has been some sort of misunderstanding or they've traveled, they've left the jurisdiction, this is going to be a place where they fail to appear, and you might look out for some sort of warrant for their arrest, which we're going to get to as well. Sorry, I didn't mean to go forward like that. So to make that charging decision, prosecutors are bound by state and ethical rules. It's actually a pretty low standard. In most places it sounds something like good cause. There are other office sort of standards like I have a reasonable belief that I can prove this case beyond a reasonable doubt. So it's kind of convoluted, but generally the ethical standard is a fairly low standard, and it has to be analyzed based on admissible evidence. So that's what the prosecutors are sort of looking at as they make that charging decision. So things that a prosecutor may look at, right? They're going to be analyzing this as they're making their charging decisions. They're going to be looking at victims and witnesses. Who is available, who's not available, who's credible, and whether there's a hearsay exception that may allow out-of-court statements to come into evidence. So an example that I saw a lot in my work was a case where a victim of trafficking had stolen from a client. So this is going to be like a buyer who had reported to the police a missing credit card or a missing watch, and most likely they had reported this to the police for some sort of insurance purposes and not because they actually sort of wanted to go through with a prosecution. So those cases would be referred to me, and then when I was looking at whether to make a charging decision or not, the victim in the case, the buyer who had the watch stolen, would not appear subject to my subpoena. They would just never come to my office and never talk to me and refuse to give me a sworn statement. So obviously that's something that I have to consider as part of whether I'm going to file charges of theft or not.
And Jane, this analysis, analysis is it's kind of beautiful, right? Because it breaks it down into the different quarters that prosecutors are responsible for analyzing. The analysis process is lengthier, I would say, more intensive, the more serious the crime, right? The analysis that you're engaging in. When you're talking about a lower level crime, a misdemeanor crime, a loitering or prostitution charge, these charges are very serious in the life of the person that's been charged, the victim of trafficking. But they're going to run through this analysis really, really quickly. But second, I also wanted to highlight this quarter that says other, and that is discretion or priority. There is an opportunity there, I would say, especially with prosecutors who are trained and sensitive, to raise the issue of being a survivor, of being a victim of gender-based violence or of human trafficking, and hoping that there is some influence in how the other parts are considered. There might be an opportunity there as well for an open case depending on what the charge is.
And I'm glad that you're highlighting that, and that goes hand in hand also with the requirement for prosecutors to analyze defenses. And so they should be analyzing defenses such as self-defense or duress. And in some jurisdictions, there's an actual defense that's statutory about being a human trafficking victim. So those are things that the prosecutors are tasked with doing and have an ethical obligation to do. But of course, they aren't always the ones with the pertinent information to do that analysis. So if you're ever working in a case where you're still that early in the process and somebody's just been arrested and a prosecutor is making the charging decisions, this is a great time to sort of try to intercede and provide some information to help them make the appropriate analysis at this point. So sometimes there's going to be no charges brought at that arraignment. So your client may have appeared in court and there are no charges brought. And so again, this is an easy place for there to be a misunderstanding of what happened, because we can, of course, decline a case, we can take no action, we can drop charges. That language is all used fairly interchangeably. A judge may also just find there's no probable cause after a hearing, and a grand jury could come back with no true bill on a more serious case. And so that's often what happens, right? No charges are brought at this point. Usually there's no, explanation provided. It's a quick 2-second process that happens in court. The complicated part comes when your victim appears in court and I'm going to do these out of order here. Your client appears in court and the prosecutor doesn't file charges, but not because they're dropping it, but because they want more time for whatever reason. So those arraignments may be delayed, and they can be delayed several times. And it could be because the prosecutor's waiting on paperwork. A witness failed to appear and I want to give them another opportunity. The police officer is on a 2-week vacation. I'm waiting for some test results on, whether it may be a drug case that was part and parcel of an arrest. So there's lots of reasons why these cases can be delayed. And
can I just chime in, Jane? We are talking about working with victims of human trafficking, and your client is a victim of human trafficking, but keep in mind that when they are going through this criminal justice system, they're going to be categorized as defendants. And when they are categorized as defendants in the stolen watch scenario that Jane mentioned earlier, that victim, as she mentioned, was in fact the buyer, right? But the defendant in the case that she mentioned might be the client that you're working with, who is a victim of human trafficking. So just to keep those terms clear, because it does become a little bit mixed when we're talking about victims of human trafficking going through the criminal justice system process.
Absolutely. And if there are formal charges that are pressed against the defendant in court, the victim that you're working with, they are going to also usually be provided with discovery. That may just be handed to a public defender standing in court, and your client may never actually receive that packet, but they have a right to that. So the question of who may actually have already these copies, the victims that you're working with, they may have a copy of this discovery, which would be great because it's really everything the prosecutors got at that point. The other thing that happens at arraignment, especially with those misdemeanor low-level crimes, is that a plea offer is conveyed. These are kind of turn and burn cases, especially in your big urban jurisdictions. We don't want these set for trial. We don't want to have this case in our docket any further than this arraignment. So arraignment, charges filed, discovery passed, and a plea offer immediately conveyed and hopefully taken case, off my docket. And that's really where I think a lot of the victims of trafficking and the people you'll be working with, that's probably exactly how they racked up, any prior convictions that happened. It happened in a whirlwind, and they were given a plea that didn't make them do anything, didn't have to do jail time, didn't have to do any services, and it was sort of a credit for time served or a CTS plea. That would be the jargon, and it was just all over in a minute. And so that's all happening at arraignment. Now, with For Whatever Reason, the case, sort of moves beyond that, and truthfully, the prosecutor doesn't want it to either at that point. But let's talk a little bit about how that does move on if we get past that point.
And often that's a volume issue, right, Jane? I mean, we're just talking about whether it's a prosecutor's office or a public defender's office is being very under-resourced and often overwhelmed by the number of cases that are coming in, the wide variety of cases that go beyond this issue of human trafficking. It's just a numbers, I hate to say game because these are serious issues, but they have to have most cases plead out. I mean, it's not through any failure to take cases seriously, although some might say that is the case on certain kinds of cases, but it is that most cases are not going to go to trial, right? I mean, you're mostly looking at more serious ones that are potentially going to be put on for trial.
Absolutely. And again, this is a place where you may have a wide range of outcomes based on your jurisdiction. The more high volume a jurisdiction is going to be, the more likely you've got, a case that something like this that came to me before I started doing this work, sort of looking back, this kind of case would come to me and they would be credit for time served, case would be over, court costs would be, put on, and that would be it, But if you're in a smaller jurisdiction where you've got more time and this is an issue that people want to spend some, make an effort with, then it might look very different, and you might get, some prosecutor, asking for jail time or something like that, and then you're more likely going to move forward to trial. Also, cases will move forward to trial if there is a defense attorney that's maybe spotted an issue that this defendant is a victim of human trafficking, and they're advising their client not to take a plea because they think they have some good defense. Or the more serious the case is and the prosecutor's not able to offer a really easy plea, then we're moving on to trial. But through each of these processes, your client may have received a notice to appear. And one of the big problems I see here is that these notices to appear are often provided at the time of arrest, when that's not something that they're probably focused on. It's like that little tiny box at the bottom of the piece of paper. It's provided at a bond hearing where someone is just really anxious to get out of jail and they're not necessarily paying attention and putting it in their calendar, or it's provided via U.S. mail to the address that the person who was arrested has provided to police at the time of the arrest. So I'm sure all of you can kind of figure out how this notice to appear may not be incredibly effective. And so a lot of the cases that I reviewed and a lot of the victims that I worked with would have these long histories of failures to appear. They didn't come to court after they were required to come to court, and a bench warrant would be issued. So if somebody received notice to appear and they failed to appear, they're going to have a bench warrant issued for their arrest. Now, bench warrants subject somebody to arrest. So if somebody then is caught, they're pulled over for a traffic infraction, police officers are going to look them up in the system, and that bench warrant is going to pop up, and instead of receiving some sort of traffic citation and being on their way, they're getting booked into jail and held until they can appear before a court and explain why they failed to appear before. The big kind of key here, and I think Vivian can talk about it too, is the fact that you may be working with a client who has no idea that there is an outstanding bench warrant out there. And when you do this background check and you're looking at criminal histories, you may come across a client that has a outstanding bench warrant. And so that, that's going to affect bail and bond. And sometimes it actually gets converted into, instead of a bench warrant, an alias capias or an AC. The big difference is that a bench warrant, nobody's actively going out and looking for this person. It's just something that's in the system and it's subjecting them to arrest should they ever kind of come into contact with the police. That's different from the alias capias, where there may be police that are assigned to actively go out and find somebody. But if this comes up in one of your cases, it really is something that should be referred to a criminal defense attorney to handle. I didn't know if Vivian wanted to say anything more about that.
I mean, I would just say that the only thing, I don't know, Jane, if you've heard if across the country is different police departments are either not aligning themselves with ICE and with the Department of Homeland Security, or they are. If they are using bench warrant lists as a mechanism for tracking people down. I haven't heard of that happening, but I don't know if you're getting that information on your end. But if that is the case, then that would be something that would be troubling. But yeah, absolutely. Any kind of open cases or open bench warrants are going to have to be dealt with a criminal defense attorney consultation when you're engaging in doing vacatur or expungement work.
I haven't heard that either, and I don't, so hopefully no one else is hearing that as well. But if you are hearing something about using those bench warrant rules for another purpose, that obviously would be something we'd be interested in hearing about. So we've sort of got to the point where your client, the defendant, your client has been arraigned on charges, and a plea has not been taken. They're going to be set, that case is going to be set for trial. Sometimes that trial hearing is the next hearing. There's nothing in between arraignment and trial. Alternatively, a lot of judges set a status hearing, sort of hoping to resolve the case or kind of managing their docket a little bit. So depending, again, on your local sort of practice, you're either going to get a trial setting or you're going to get a status hearing and then a trial setting. And that trial setting, there can be, the more complicated the case, the more status hearings you may have. And at the status hearings, it's typical for the judge to inquire, the readiness of both sides. And either side can take a continuance for one reason or another. It's really meant to ensure that there are sort of this speedy trial. And that's on a legal matter. There's a right to a speedy trial, but also just like on a practical matter, some judges are a little bit more micromanaging and have these hearings. If there is going to be more discovery, they'll sort of set that, and there will be ongoing plea negotiations at every stage here. Typically, in my practice, defendants were not required to appear at these status hearings. So this is a place where, again, if you're working with a victim who was a defendant in a case that was set and reset for all these status hearings, they're not required to appear. They may have really no information as to what was going on at those status hearings. And so
my experience was different, Jane. We always had defendants appear, even on discovery and other things. It would, every once in a while, you would have defense attorneys waiving their appearance, or but often defendants were appearing as well. And then, I mean, the only other thing that I kind of wanted to throw in the mix is that your client, who is a victim of human trafficking, might have come into this system originally in a defendant posture, and it might be that they turn witness for a prosecutor on a larger trafficking investigation and prosecution of their trafficker, let's say, and so they are now viewing this lengthy status hearing schedule that we're discussing from the perspective of a potential witness on a case. And so they're waiting to hear as all of these things are happening. And so that's kind of the other side of, like the victims that you're working with might be waiting to see what's happening as this process moves very, very slowly through the courts.
Absolutely. And I love the fact that we are demonstrating to you how unique each jurisdiction is just because of our varied experience here, and also just the various mutations these cases can take. And definitely, if your client was either a defendant or a witness, if there is a sort of related trafficking case where your client was maybe originally arrested or listed as a witness or as a victim, if there is that connected between a bigger case, this whole process is going to be much more convoluted, and you'll really need to wade your way through it. And I think, Vivian and I are here to help you with that, but that's always kind of a thing to keep in mind. Your trial setting. So most of the time, something is set for trial. It is not the one and only case on a particular day. I would walk into court on a Monday and have 80 cases set for trial. And we would just, I never really could tell which one was going to go. Again, that's a place where your client may appear for trial and then, doesn't really understand what's happening because their case doesn't actually go to trial that day and they were sent home. And so these are times where it can really lead to confusion. There are other situations where a case is like specially set for some reason. And again, this is probably going to be a situation where there is a much more serious case somehow attached, whether your client was themselves charged with a more serious crime, or there was this sort of concurrent prosecution of a trafficker or something like that. But throughout this whole process, there's always going to be opportunities for cases to be continued, for there to be ongoing plea negotiations. Trial settings, however, I even would have the defendants would be there for trial settings. So I just want to note, as we're kind of getting towards the end here, is that at any point in this process, charges can be dismissed, a plea can be taken. And so that's that ongoing piece that's always happening. But there is a difference between a case being dismissed after it was filed and the case never being filed. And so it may or may not affect how you file your paperwork, but I think it's important to note that if a prosecutor's office never files any charges, arrested but never files any charges, that's going to look a lot different, and there's going to be much less paperwork than if the prosecutor filed charges, went through part of this process, and then at some point decided to drop the case, to dismiss the case. So that's something you might want to just make sure you kind of are able to differentiate between your cases. And it really depends on what kinds of records you're going to be looking for. So when you're ready for trial, the court's going to have a lot of say over what case is going to go to trial when. Scheduling is always a big deal. What is the police officer's schedule? What's the prosecutor's schedule? and really what the judge's schedule is. And oftentimes this can be a place where there's a lot of pressure to resolve a case. And defendants are pressured into taking pleas. Prosecutors are pressured into, offering pleas or dismissing cases. And so all that can really kind of happen in this very pressurized morning in a chaotic courtroom. So you can imagine that, trying to get that information of exactly what happened could be difficult. In trials themselves, there's a big range of what this might look like. It could be a jury trial. Where I was, every case we did jury trials. There were no bench trials for the most part. In other jurisdictions, it's really common that all you're doing is a bench trial and a judge is making the determination.
And I mean, just to say, like, what I would see mostly being tried would, in our situation where we're talking about human trafficking, would be probably traffickers being prosecuted on a trafficking charge, a more serious charge. It's a lot less likely that you're going to see a trial taking place for a loitering or prostitution charge in general.
Agreed. So if a trial was conducted, and these are the sort of 4 ways that it may be resolved. A plea. In the middle of trial, someone can take a plea. A dismissal. Likewise, the prosecutor starts their case and the officer starts testifying and it does not go well, probably because there was that pre-printed arrest form, and the prosecutor decides to dismiss the case in the middle of trial or whatnot. And then there can be that verdict and that hung jury. I'll quickly go through some of what that can look like. So dismissal at trial, the prosecutor could have expected a witness to appear. The witness does not appear, and the judge is not, likely to grant a continuance. There's been some sort of suppression motion and evidence was not able to be admitted. That's typically going to be in a case where, and I saw this a lot, where alongside of a prostitution charge was also a charge for possession of narcotics. And so that possession of narcotics, those drugs need to have been properly impounded. There needs to be chain of custody. They need to have gone to the lab and been tested. And so that's a very complicated evidence admission process. And so if I was unable to establish that chain of custody, then all of a sudden my drug charge is dismissed at trial. Or, I just didn't get the testimony to establish the elements of the crime. Or the defense put forth a defense. They were able to come up with a defense that I just couldn't overcome. And so I might just dismiss it at that point. Or, reasonable doubt. Although typically that doesn't happen mid-trial. The judge can also dismiss a case in the middle of trial. So if I put on, as a prosecutor, I put on my entire case, the judge can say, hey, you did not establish even a prima facie case, which is an incredibly low standard. You just didn't do it. Dismissed. Defense doesn't even need to put on a case. Alternatively, at the end of the entire case, when the defense has put on their case, the judge could make the determination that no reasonable juror could find the defendant guilty. That's a legal standard that's applied at the end of the trial.
Jane, would you say that in layperson's terms, the judge is basically saying the prosecutor didn't do their job? Like, they didn't do enough. And so we're not even going forward on this. Like, there's no point in moving forward.
Yes.
Yeah.
And it's usually not a surprise to the prosecutor. Something has gone terribly wrong. Like the police officer is unable to identify the defendant, right, in the middle of trial. And so as a prosecutor, I probably would just have dismissed that case, but some prosecutors, could potentially, make arguments and they want the judge to dismiss it. But yes, something has gone wrong. Prosecutor did not do their job.
And a lot of that could also be local politics, right? Like, we're saying that criminal law is local, but there's a lot of politics involved in these policies around charging and moving forward on cases. And so that's just something to also very much be aware of.
Yeah, and I think that's actually, something that we could have come up with at the beginning of this is that judges, their courtrooms are sort of their little domains, and they have a lot of power, especially when it comes to lower level offenses, about how they're going to, kind of handle these cases. And so I have definitely been in courtrooms where a judge just hated prostitution cases and just dismissed them all. Likewise, in the case of marijuana, somebody just hated marijuana cases, dismissed them all. Or sort of the counterpoint to that, some judge who's got really sort of a pet peeve or, has that kind of case that they really are very strict about. And so that's going to affect what cases go to trial, what pleas are accepted by the court, how cases are prioritized. And so there's going to be a lot of that, especially in those lower level cases. Okay, so even the verdict is not simple, right? So obviously there can be a guilty and not guilty. Those are the ones we're used to, right? But then we've got to look a little bit further, and you can be found guilty of all charges. You can be guilty of some charges, not of others. And you can be guilty, or you could be found guilty of maybe lesser included charges or lesser charges. So an example might be that somebody goes to trial for, and I'm going to just throw this out here, it'll be relevant in one jurisdiction in the United States, I'm sure. Somebody's arrested for prostitution, but the jury comes back, doesn't find them guilty of prostitution, finds them guilty instead of loitering for the purposes of prostitution. And one is, a misdemeanor where they could potentially do, excuse me, a year in jail, and the other is a county code violation where there's a fine. So if that happened to your client, they would sort of walk away thinking they had won the day. They're not going to jail. They've been, assessed them a $60 fine, and that's how that's going to be perceived. And in fact, they were found guilty of a lesser included crime. A hung jury, this is always a possibility. That just means, a jury can't come up with a unanimous decision. In lower level crimes, it's usually a jury of 6. In higher level crimes, the jury can be as large as 12. But the real takeaway here is that it may, again, be perceived by someone involved that the case is over, that this is a win and they get to walk away. But in fact, the case is not concluded. It does require the prosecution to sort of take a look at it and make a determination of whether they're going to retry the case or not. And there's a new speedy trial window that's applied, and that can sort of maybe affect some things going forward. But the case is not concluded, and in fact, the defendant at trial will be required to appear back in court, and that could be another opportunity for someone to, sort of fail to appear and get themselves in trouble with a bench warrant. So going forward, and hopefully we can sort of answer some of these questions I see in Q&A because we have some time here. But the takeaway really is to maybe make sure you're gathering all the information that you possibly can and not be looking to the victim of a human trafficking case that has gone through this very convoluted, very scary process. Don't be looking to that victim to give you the best information possible about what happened to certain cases and what processes they went through. So look towards the different ways that you can gather this information, whether directly through the court, through police departments. I really would encourage people to look for records from the prosecutor's office themselves. Gather all of the information, and then do your best at deciphering local and state terminology. If you're lucky enough to be working in a jurisdiction that has a robust human trafficking response, the prosecutor's offices, typically those prosecutors, hopefully, are really aware of the nuances of this type of response to trafficking. And I know I was lucky enough to work in a jurisdiction where my elected official, Catherine Fernandez-Rundle, she told me, you know, I know that we've prosecuted victims. I know that we have done that, and I'm sorry about that, and I would like to fix that in any way that I can. Well, that really, you know, sent the message from, you know, the top down that our job was not only to be going after the traffickers, but really where possible and where identified to be remedying both our past mistakes and going forward not to be making them again. Not all of you are going to be working in jurisdictions where that's really the message that's being sent down. So I'd say, you know, leverage the resources that you have. Reach out to Vivian and myself and see if we can help you with your jurisdictions. And where you do have jurisdictions that, you know, are really that forward thinking, use the prosecutor's offices as resources as well. You know, they'll help you decipher some of this. They'll let you know sort of the lay of the land when appropriate, so that you really know what should we be filing. For example, a lot of times the statute might say only these types of crimes can be expunged or vacated, but the prosecutor's office has a lot of wide discretion to sort of go above and beyond that. So when you have a working relationship, you might be in a good place to even do more help for the victims of trafficking that may have, you know, low-level crimes or even more serious crimes that were committed while being trafficked and part and parcel of that trafficking. And then when you get these reports, you know, really look at how to analyze them. Reach out and make sure you're understanding the terminology as best that you can, those little acronyms and things like that. And hopefully, you know, do the best work that you can on behalf of the victims and your clients.
And I think this is where alliances could be really helpful. I mean, you mentioned reaching out to kind of forward-thinking prosecutors' offices, but it might also be public defenders or other kinds of advocates or other or civil attorneys in a particular jurisdiction who can help you walk through some of the records and the documents that you're looking at. And now that brings up some of the questions that have come up in terms of how do you access a prosecutor's file? How do you get records from a prosecutor's office? And so those are some of the questions that have come up. And how would you suggest, Jane, that folks go about doing that?
So a public records request is how I've seen it done. I'm sure there are experts in this field. I was always the one responding to the public records request. And these, again, are going to be specific to your state's. But that's where I would start doing some research, and I'm sure that the ABA can help some of you sort of figure out what's going on in your state. But there usually is a pretty standardized process to get these public records. But you may want to start with a simple court search, which a lot of those are just online, and they can give you the initial kind of hook of where you should be looking.
And we, through the Survivor Reentry Project, where you're working with survivors of human trafficking, if you go to the next slide, you'll see our website. There is a way of requesting technical assistance through that website, which is ambar.org/SRP, and we can help you walk through some of the issues that we've talked about and that we've raised. I also want to put out there for folks that there are future sessions of this webinar series that are going to dive into issues a little bit more deeply. So we're going to be talking about the impact of arrest and conviction records and really knowing the immigration consequences, for example, on convictions. And so the next session in this series is about impact of arrest and conviction records on April 10th. But then we're going to be walking through the actual bringing of a vacatur motion on June 5th. And then best practices of working with survivors of trafficking and vacatur cases, and so some of the issues that are brought up there. And as we talked about, the impact of immigration on vacatur, immigration status and immigration convictions and things like that. We're going to be doing that in the summer, and then also looking at use of interpreters in this series. And so building on each session, we're going to be looking at how to do some of these records requests, how to process the vacatur motions, and we're going to be walking through each of these step by step. But I do want to talk about one of the questions that came up, which is should advocates engage in advocacy, asking prosecutors to drop cases. Like we talked a little bit about that window of time before a case is filed or charged. At that stage, should advocates be engaging in asking prosecutors to drop cases and looking at the interest of justice because the defendant is a human trafficking victim? They can obviously do that throughout a case. The only thing that I would say is you can always engage in advocacy, but I would think that if someone is represented by a criminal defense attorney, you want to do that in partnership with them. You do want to be mindful of any conversation that is had with a prosecutor. That's not a private conversation, right? Like they're in a position where they're actually either considering charging someone with a crime or moving forward on that charging decision. And so I would think, be in your client's best interest to do any kind of advocacy in partnership with their criminal defense attorney. Jane?
Yeah, I would say exactly the same thing and really encourage you to do that. I train from that prosecutor's viewpoint, and I really talk about what I think is one of the most difficult pieces of the work from the prosecutor standpoint is trying to figure out the person before me, right? Is this a victim or is this somebody that's culpable for a crime? And sometimes that looks like a sliding scale. And my job as a prosecutor is trying to put somebody on that sliding scale. And really what's on my mind right now as I talk about it is somebody that might be, considered a quote bottom unquote in this process, right? So it's somebody that's been arrested and I'm trying to figure out where to put them. And I say that's really difficult for us to figure out, but mostly because as a prosecutor, I'm the last person to have the information that I really need to make those determinations, right? Because what kind of information do I want? I want information about somebody's family history. I want some information more about, sort of the relationship between this person and other people that might be involved. All of that isn't information that I readily have. And so the evidence that's coming before me that I'm looking at may be pointing directly at, the person who's in front of me as a defendant. And so those of you that are working in places where you have that information and that you can really advocate on behalf of someone and try to paint an alternative picture for me, as a prosecutor, I want that information. Do it in conjunction with the defense attorney so that you're looking at it from that confidentiality piece that Vivian really correctly brought up. But the earlier you can sort of get yourself in front of a prosecutor as an advocate on behalf of your client, then the less likely all those collateral consequences that you hear about in subsequent webinars are going to start getting put into action, right? Because yes, an arrest sort of has some collateral consequences, but those consequences continue to be more and more serious the further that case gets along that line. And so if you can kind of stave it off early as possible, it's really, there can be some huge benefits to your client. And prosecutors, I know there's, like everybody, there's good ones and bad ones, but for the general and who we work with, they want to be doing the right thing. They want to be making those decisions with as much information at their disposal as possible. So I would encourage that with that caveat of that it needs to be done in conjunction with their defense attorney.
I mean, and we're talking to Jane, who's a prosecutor from Equitas, who has extensive training in these issues and is really deeply knowledgeable. Not every prosecutor has that same level of training and expertise. And so while for a lot of the cases that you're going to be working on in terms of vacatur and expungement, these are old cases. Everything has been done as in the past, and we're moving forward. But for those of you who are working on potentially open cases, it's really important to work closely with public defenders, criminal defense attorneys, and also prosecutors' offices to just raise awareness about the issue of human trafficking and how many victims are being moved through unknowingly, unfortunately, through criminal justice systems. And so, raising awareness and building alliances across these different professionals, I think, is really important outside of a specific case, right? So that when you're talking about bringing together people for roundtables to raise awareness about human trafficking, or if you're talking about doing some kind of a task force, hopefully that alliance work and that awareness raising work is happening in anticipation of and outside of a specific challenging, difficult case where you are working with someone who you very much view as a victim, and unfortunately the prosecutor is miscategorizing them as a defendant and not someone who they view as a victim. And so hopefully you can be on the same page in handling that case if you've already built up some trust, if you already know some of the different professionals that are working in this sphere in your local jurisdiction. But again, a lot of the cases that you're going to be working on, if you're doing post-conviction advocacy, are just that, post-conviction, right? We're talking about vacatur and expungement, and it's after the fact. Let's see, we're just checking to see if we have any other questions. We're still able to take some questions. We're looking at advocacy with prosecutors' offices, which we just discussed, and then how to get these records. And again, I would just direct you to ambar.org/SRP for more information on future sessions that are going to dig a little bit more deeply and in a detailed way into the vacatur motion and expungement process. This is just a very basic introduction to the criminal justice system for folks who are new to that system, who want to have a better understanding of how, in general, that system works. And yes, this recording and slides are going to be put up on that same website page, where you can also find a request for technical assistance for any questions that you might have, and we will try to answer those questions. Jane, anything else that we should raise or touch upon?
No, I just encourage everyone as you move forward and listen to the rest of this series, which I am personally looking forward to listening to as well, that you just remember that the resources are out there, because inevitably you're going to come up with a case and will not have mentioned that particular sort of oddity that happened in a case you're working on, and we're always here to help you kind of work your way through those difficulties. And thank you for the work that you do in this regard.
Thanks for joining us, and please tune in for upcoming sessions of this webinar series. The next one is going to be taking place, as I said, April 10th. It's the impact of arrest and conviction on April 10th at 1:30 Eastern Standard Time. Thanks so much, everyone.
Thank you. Thank you, Jane and Vivian, for this great presentation today. On behalf of the American Bar Association, the Commission on Domestic and Sexual Violence, thank you for participating in this program. To learn more about the sponsors, visit the ABA website at www.americanbar.org. Thank you, and please complete the evaluation. We value your feedback.